Floor. I want to begin by thanking the Court for the opportunity to address these important issues today. Emergencies, by their nature, are unpredictable, but one common thread in all emergencies is that a flexible and adaptable legal framework is crucial to enable government to respond to changing circumstances and protect the public. Now, the legal framework the legislature established in Chapter 127A recognizes this important fact. We've heard a lot this morning from opposing counsel about the need to conform to and to honor the legislative framework that the legislature created. And to be clear, we absolutely agree with that. In issuing emergency proclamations to address the COVID-19 pandemic, the governor has been faithfully applying and working within the legal framework that the legislature created. With the Court's permission, I'd like to begin by discussing that framework, which is found in Chapter 127A. As I'll explain, we believe the text, purpose, and the case law all counsel in favor of our reading of the statute. I'll then plan to address appellant's constitutional challenge, but I can just briefly, I think Your Honor is exactly right that this claim was not alleged in the operative complaint, and so it's our position that it is not properly before the Court, but if Your Honor wants to discuss the merits, I can certainly do that. And then I'll also underscore that the challenge on the statutory question fails for a number of reasons, not only on the merits, but also because of the lack of a private right of action. And then finally, I can address some of the justiciability issues that we raised in our brief, and of course, I welcome the Court's questions. So I think everyone agrees that in terms of the text of Chapter 127A, the key provision is Section 127A-14. And I think it's absolutely right that you really have to read subsection D in connection with subsection A, which, in our view, provides a very clear delegation to the governor of the authority to declare a state of emergency. And we heard a lot about the letter A and how that is a significant difference here. And it's I don't really follow that argument, to be honest, because we're talking about a state of emergency, and so it's our position that each proclamation creates a separate standard state of emergency. And so each time...
Let me interrupt just briefly. So you agree that at 60 days that proclamation is done?
Yes, that's right, Your Honor. And so we agree that, to some extent, people have been sort of using the term either in the media or elsewhere about extending an emergency proclamation. And so it's our position that legally that's not correct. That what happens each time there's an emergency proclamation is there's a separate, standalone determination by the governor that a state of emergency exists based on the facts as they exist at the time the proclamation is made. And that this actually plays a really important role because it forces government to deliberate and to determine whether the circumstances continue to warrant these extraordinary powers. And we agree that a state of emergency is not the ordinary course, and it is everyone's intention.
So how does it end, Mr. McLean? Can a governor just go on and on and on and on forever declaring emergencies?
No, Your Honor, and I think there are a couple of answers to that. I think the first answer is found in the text of the statute itself. There's a definition of what an emergency is that appears in 127A-2, I believe. And so, an emergency isn't just anything that the state wants. An emergency is defined as an occurrence or imminent threat thereof which results or may likely result in substantial injury or harm to the population.
But what is the mechanism? Because the statute does have some very strong language, which has not been challenged in this litigation to date, about the governor being the sole judge of the emergency.
Well, I think that's right, Your Honor, and I think it's important to read that language in context. So the way I interpret that language would mean there is a presumption that the governor will be the one to make that determination. But we acknowledge that all government action, whether it's a statute or executive action, certainly has to comply with the federal constitution, for example. So if you got to a point where an emergency proclamation, given the circumstances that exist, wasn't supported by a rational basis, That, for example, would be a federal constitutional limitation. And we certainly we embrace that reading. We agree that that is potentially a valid type of claim. It could be brought up at state and federal.
But your position is that, and I'm not sure Mr. Victor would disagree, that there has been no allegation in this case that there's no rational basis for the supplemental proclamations.
Absolutely, Your Honor. I completely agree with that. And I think it's important to really underscore that this is, on the statutory issue, a very narrow claim. I mean, there are some very broad separation of powers issues that don't appear in the operative complaint, but the statutory claim is narrow. It doesn't allege, for example, a bad faith use of this or an abuse of power in that sense. It doesn't allege the factual basis doesn't support the emergency proclamation. And so I think that's important when we think about, well, what are mechanisms for potential enforcement here? Absolutely. And I think with respect to Chapter 127A, we talked a little bit about the text, and I think the real, the key point here is that it's the appellants who want to rewrite the statute. They want to add an additional subsection that says no more than one state of emergency may be issued for any underlying emergency. And that's simply not the statute that the legislature wrote. And we spoke a little bit earlier, or the court spoke earlier about the role of legislative intent and purpose. And I think it's important here to sort of bear in mind that the legislature itself told us what its purposes were in passing in 2014 this statute, the framework that appears in 127A. So in 127A-1, the statute specifically said that its intent and purpose was, quote, to provide for and confer comprehensive powers to the governor. The legislature also said in that same...
But Mr. McLean, I don't think he's challenging the governor's powers. It's more about, the governor has that power for 60 days. So I don't think that, I mean, I agree with you on your reading, but I don't think that's the issue. It's the 60 days.
Understood, Your Honor, but I think that it's important to read that 60-day language in light of its purpose. So the legislature tells us that, for example, in 127A-1, that it was passing the statute to address the possibility of the occurrence of disasters or emergencies of unprecedented size and destructiveness. So the legislature told us that they were really concerned about major disasters. And so it's our position that it would be paradoxical to say that although the legislature was concerned about really big disasters, potential disasters that could last for potentially a long time, that it also wanted to put in a drop-dead date of 60 days that would radically change the scope of emergency powers in the state. And we've reviewed the legislative history, and we certainly can't find anything that suggested that the legislature was intending to make this huge change in state emergency power that on appellant's account it was doing. But what the legislature did say was that it wanted, when we read the statute, it wanted it to be liberally construed to effectuate its purposes. And so we were told that the purpose of the statute is to address disasters of, in the legislature's words, unprecedented scale, or unprecedented from the statute. And then we're also told to read the text liberally, not narrowly. So I think that when you take those principles and apply them to the text of 127A-14D, there's a clear understanding there that this was intended to be read broadly, not narrowly.
So in a situation like this, and you have to recognize this has gone on for a long time, and we're up to, I don't know how many proclamations, but we've got quite a few in a row now. I mean, is there any bottom to the threshold of what continues to be an emergency? Is it hospitalizations? And I know that the governor's a judge, but how does the citizenry assess that and say, hey, now's the time to jump in? I mean, assuming I agree with your reading of the statute, that it's not one and done. I mean,
well, I think that raises a really important issue because it ultimately comes down to the governor's judgment, but also the range of advice that he receives from, for example, and in particular, the Department of Health and others. There's a lot of expertise available to the governor that can help to inform the determination of whether a state of emergency is warranted. And
Right, but okay, so I hear you, but not everybody trusts the experts, I guarantee you that. But still, there has to be some, and I think one of the things that's in the briefs, and your brief had 83 footnotes, it was a lot, but we did read them, about the basis for the governor's proclamation. But I think if you read the complaint, and I'm sure you have, there is people have been hurt by this too, and it seems, that there ought to be a way for redress at some point if it just keeps going. I mean, what if COVID never goes away? Does that mean we forever live under emergency proclamations?
well, I think, Your Honor, I think one of the most important checks that exists is the legislature can amend Chapter 127A at any point. We certainly can see that. So if the legislature wanted to pass a new section to 127A that says, and there will be no more states of emergency related to COVID-19, they can certainly pass that, and it would be, that is something that people, can certainly make themselves heard, and that's an important check. But I want to emphasize, to turn back to the questions we had about legislative history, that the legislature not only hasn't done that, but actually has, in some ways, has ratified the interpretation of 127A that our side is advancing here. So I think there was Judge McClellan mentioned earlier about the foreclosure, the eviction moratorium bill. I think that's a good example of something that is assumes the continued existence of these emergency powers and builds on that. And there's actually an even more express acknowledgement, I think, and it appears in Act 185, which was enacted last year in June 2021. So this is almost a year after, according to appellants, the state of emergency couldn't have existed. But in Act 185, the legislature made a number of findings, and I think they're really important because they underscore how the legislature is continuing to think about these issues. So if I may, I'll just read briefly from these findings. It says, the legislature finds that COVID-19 has created great challenges to global health, the economy, and way of life, and that the governor and county mayors have had to exercise their emergency powers under Chapter 127A to impose rules aimed to control the spread of COVID-19. And the legislature went on to find that the enforcement of these rules.
I thank you for that, but I want to circle you back to where I circled Mr. Victor, which this is not an appeal that really goes to the substantive merit of the governor's proclamations. This is an appeal from a motion to dismiss that was granted, and your motion said they failed to state a claim on which relief would be granted. Now, on count one, I think we're all on the same page here. It really depends on how this court interprets 127A, but maybe you could, you can finish, but please do get to count two, because I think the mootness issue and the exceptions to the mootness issue are, that's something you need to address for us today, please.
Absolutely, I appreciate that. And I would just commend Act 185 to the court. So I think with respect to count two, I think it's important to emphasize that in some ways, responding to the allegations of the opponents has been challenging because it's been a moving target. When you look at the operative complaint, it asserts a void for vagueness challenge, and it doesn't assert, as we mentioned, a separation of powers claim. So I think they could file a new lawsuit, or they could seek leave to amend potentially in the circuit court on remand. If there were a remand, they could just file a new lawsuit to assert these separate issues related to separation of powers. But I think our arguments initially with respect to mootness were made in response to their arguments that particular provisions of emergency proclamations were void for vagueness, right? So it includes allegations that things like the interisland travel restrictions were vague, that it was difficult to understand different states, different emergency proclamations as they had been worded at the time. And so when we saw this void for vagueness challenge as really being a challenge to particular language that had been used in particular EPs that no longer exist and relate to restrictions that are no longer in place. And so it was our view that is moot with respect to, it's no longer in force, for one thing. And then with respect to capable of repetition, it was our position that they have a burden of coming forward to say, that there's some likelihood that these restrictions are going to be enforced again. And with respect to, restrictions about beach closures or, wearing masks on the beach, it's not clear that certain aspects of how these EPs were enforced early in the pandemic, that it's likely that will reoccur in the future.
But don't you think the public interest exception might apply as well?
I think that, I can see that there is a potential argument with respect to the public interest exception. Unless I've missed it, I don't believe that exception was advanced by appellants. But, I think that I think that's a close question, Ron, with respect to the public interest exception. And ultimately, it's a matter for the court's discretion.
But Mr. McLean, you do agree that you argued mootness to the circuit court, because I see you were on the transcript, you guys did it, and you said, so with respect to the vagueness challenge, we think these threshold questions of standing and mootness fully dispose that claim. And the circuit court took you up on it, right?
Yes, sir.
Yes, okay, so, because that's what's in the order. So part of my question to you, and I was trying to pose it to Mr. Victor, so if we reach that issue and conclude that mootness does not apply here, what's next? What are you saying? What would your recommendation or request be to this court, and what do you think happens from here?
Well, I think the court would have a couple of different options. I think with respect to the vagueness claim, that's not an issue that is briefed before this court, and so it's our position that if the court concludes that the void for vagueness claim was not moot, but was it's not clear to me that falls within the scope of the appeal. I'm not sure it's one of their...
Right, because the court didn't reach the merits, right? Judge Watanabe concluded that it was she said, and this is pretty much a quote, plaintiff's claim in regards to the vagueness of prior emergency proclamations, which are no longer in effect, is deemed moot and is dismissed for prejudice. So wouldn't we have to vacate at least that part of the ruling and remand it to the circuit court?
I think that the court certainly could. I think if the court concluded that it wasn't moot, then that would be the appropriate course of action, rather than deciding it on the current record. Yes, sir. So I think one point of clarification that I do want to mention as well. When we talked, I think, previously before the circuit court about the issue of standing, and I think, with the standing issue, I think it's important to emphasize that when we talk about standing, it kind of encompasses multiple different facets. So there's the issue of whether there's a private right of action, which I think in the past sometimes courts conflate that with standing under the Declaratory Judgment Act. And then there's also the separate issue of standing under the DCA 632-1. Now, given some intervening case law, I think we're willing to concede at this point that there is standing under the Declaratory Judgment Act. So under the particular factors that the court looks at, we think intervening case law, in particular the Legal Women Voters decision a few months ago, likely does establish that the defendants have Declaratory Judgment Act standing, but it doesn't establish that they have a private right of action under Chapter 127A. So I think with that, just wanted to make that point of clarification.
I appreciate that, and I studied that part of your memorandum as part of your motion to dismiss, and it seemed to me, based both on what you put in writing and what you argued before Judge Watanabe, your standing argument stemmed from your mootness argument.
I think that's right. I think to some extent they're allied concepts here, but if it's helpful, certainly we're happy to make that clarification.
Thank you.
So I think that it's important, we heard a little bit about the Wisconsin case, the Fabric v. Evers, and I just want to briefly, we I think address that in our brief, but I do want to emphasize that the text of that statute is really quite different from what we have here. And in the Wisconsin statute, there's a particular language that says a state of emergency will not exceed a certain number of days unless the state of emergency is extended by joint resolution of the legislature. So in the Wisconsin statute, you had not only a time limitation, but a specific discussion by the legislature of what happens after that. And so it refers to, okay, well, the next step after the 60 days is you go back to the legislature and you ask them for an extension. That language does not appear anywhere in the Hawaii framework. There's nothing that even by implication would suggest that the sole method of getting an extension of a state of emergency is through concurrent resolution by the legislature. So the text is dispositive.
Okay, but you explained to me earlier, we're not talking about extensions. Each proclamation stands on its own.
Yeah, exactly. Right. And so I think it makes a significant difference here. So I think that sort of is dispositive there. So I think if Your Honor has any questions about the statutory issue, I mean, I'm prepared to speak about the constitutional issue, but it sounds like the court's questions are primarily on the statutory front, so I won't.
Well, I have a question. Is there a point at which the state of emergency kind of turn into a new normal, where it should be addressed through legislation as opposed to proclamation?
I think that I think that's certainly a fair point, and I do think it's important to emphasize that the states of emergency are temporary. It is no one's intention to maintain a perpetual state of emergency, and everyone in state government would like very much to get back to a regular order across the board in state government, and everyone understands that states of emergency are the exception, not the rule. So I think that is, right off the top, I think that's a really important point to emphasize. And we conceded in our brief that it's our position that as soon as the conditions make it appropriate and warrant the discontinuing the states of emergency, that is it is very much everyone's intention to discontinue the use of emergency proclamations. And so I think that certainly it's well understood that this is the exception, not the rule. And I think with respect to we spoke earlier, I think, on the question of, well, what are the limitations in terms of how long these are extended? And I think the issue of, well, if it was issued in bad faith, if it was issued without a rational basis, I think those are important checks. And so those are the kinds of checks that prevent a state of emergency or a series of state of emergencies from continuing so long that they become a new normal, as you said.
Well, and does that get us into the constitutional issue, Mr. McLean? That I don't know that anyone wants to get there, but at some point, if the emergency doesn't look like an emergency anymore, what is the trigger for analyzing? And I'm not saying that this complaint has alleged it or hasn't alleged it. I'm just saying, trying to understand, whether it's the delegation issue or, however you frame it, when other than the good faith of the government, which no one here doubts, I don't believe, not Mr. Victor, not this court, but when is the emergency not an emergency anymore? When is it, this is the normal, you've got, this is the community.
Absolutely, Your Honor. I mean, I think that those are...
Excuse me, please put your mask on.
I think to some extent those issues are a political issue for the governor and the legislature as well. But I think that it is as you say, I mean, it's a judgment call for the governor, but it's a judgment call that reflects the existing legal framework that we have, and that also can take into account our understanding of the changing science and the changing advice that the government receives. And that's not only from the state government, also from advice from the federal government and from the scientific community and the medical community. So it is certainly, I think it's a complex issue. In some respects, it's a political question, but it is certainly an important issue, and I can say it's an issue that is front and center of the mind of all the key decision makers. And I think, unless you have any other questions,
Yeah, I have a quick question. So Mr. Victor brought up a distinction between whichever occurs first versus whichever occurs later. Is that a critical distinction, first or later?
well, we don't agree that that is a meaningful distinction, and so we think that there are two, in terms of the text of 127A-14B, there are two paths to conclude that additional emergency proclamations are permitted. So the first is the reality that each emergency proclamation is a separate proclamation issued under Section 14A. I think that's the first argument, and we've sort of been focusing on that a little bit more today. But there's also a second argument, which is that there is a specific, as we say, reference to a separate proclamation, and the concept of whichever comes first, as we read that, it simply means that you have 60 days, but if you have a separate proclamation that occurs before 60 days, well, then you can restart the 60-day clock with a new separate proclamation under Section 14B. So both of those would be ways to, there are two different paths.
But doesn't it say, are we talking about shall terminate, ... by a separate proclamation? I mean, doesn't that really, if you read that with all the words, and not skip the by part, isn't that section really about how it terminates?
Well, I think it is how it terminates, but it's our position that the way it terminates is by issuance of a separate proclamation that also restarts the 60-day period. So unless you want to say any other questions?
No, I think we're good. Thank you, Councilman. Mr. Richard.
Thank you. The reason we're all struggling here is because their construction makes no sense. Your question, at some point, does the legislature get involved? Yes, at 60 days. That's what the statute says. And Judge, your point, at what point is an emergency not an emergency, and who decides this? If the governor, in his sole discretion, gets to continue to decide, then that's the answer. Whenever the governor decides to relinquish power, the governor decides to relinquish power. There is no other way to end this. The reason we're unsatisfied with that answer is because their construction makes no sense. It doesn't make sense to let the governor continually, in his sole discretion, to continue to declare another state of emergency on exactly the same facts. Otherwise, what point does it make to say 60 days and terminate? So the governor, he said in his response, well, we deliberate, we determine, they don't do anything. They might do that, but at the end of the day, the governor, in his sole discretion, makes the decision. There's only two possibilities here. Either A, our construction, 60 days means 60 days, shall terminate means shall terminate. It doesn't mean the emergency is over. It means the legislature gets involved. They decide when the emergency is over, not the governor in his sole discretion. That construction overthrows everything about this statute. And I really would implore you, please read the case in Wisconsin. That language is weaker than our language because it says, yes, it terminates in 60 days unless the legislature does something to continue it. Ours doesn't even say that. Other than that, they're identical. The issue in that case wasn't that question. The issue in that case was, does the same question here, does the governor get to continue to declare another state of emergency on the same or very substantially similar facts. They said in that case, you can't just change the whereas clause and say, okay, now we have this issue that's different or this issue that's different, just declare another emergency until whenever the governor says, trust me, now I'll decide for everybody when we're out of a state of emergency, this huge delegation of tremendous powers, which includes seizing this courthouse, which he hasn't done, thankfully. Those kinds of powers, one man decides when that ends. That makes absolutely no sense. And it overthrows everything the legislature very clearly said in that statute. I don't have enough time to go through it all, but the logic of that Wisconsin case, it wasn't razor thin. It's not different than our statute. The only difference in there at all is the legislature gets to extend. Okay, the same is implied here. The legislature can certainly come in and say, you know what? Corona's a serious thing. It's going on for a long time. We're going to give you another 60 days, or another 6 months, or another 2 years. They are the voice of the people. They are the ones who should be making the decision. That's how America works. We don't vest power in one person unless it's a real emergency, and then they get 60 days, and then it shall terminate at that point. There is no other reading of this statute that makes any sense whatsoever. The statute is clear. I'd ask you to read it and think about what on earth the legislature, why would they give such dramatic, expansive powers to one man and then just simply let him to continually agree to, so he, in his sole discretion, in 60 days can decide whether to re-elect it? It just makes no sense. It makes sense to give it to the voice of the people. Let them decide if the emergency continues or not. They're the ones who are the voice of the people. That's the only reading here that makes sense. The exact logic applies in that Wisconsin decision, and I hope you read it because that's exactly our argument here. And thank you very much for the opportunity.
Thank you, Council. We will take the matter under advisement.
Court is now adjourned.
Yeah.